Advocate Nidhi Singh from NRI Legal Services. On a routine basis, we get a lot of inquiries from people all over the world who ask us questions which they think they need answers to. My team often collects them and hands them over to me, and when the time permits, I do take them up. So I'm going to take up a couple of questions today, and hopefully people who have written them would be satisfied. The first question that we've received is, what are the rights on a mother's property after her death? According to the laws of succession in India, if a mother leaves a will, and the will is properly registered and it is a properly executed will, then the will would prevail. And if there is no will, then all the children, and if it is a self-acquired property, then also the husband has full rights on that property. So all children of a woman have full rights, irrespective of whether it is a son or a daughter on a mother's property. So here is a question that has come: can a father give his property to one son? A father, or any man for that matter, has full rights over his property, and he can give it to one son, he can give it to two sons, he can give it to the daughter, he can give it to a third person, he can give it to anybody. And the way he will give this property is two ways. If he is still alive, he can do a transfer deed, which is unchallengeable once he gives it to a person and the others do not have rights on it. And if he decides to do that. So a transfer deed, a gift deed, a sale deed, if he is selling the property to that son, any of these methods are fully legal, and generally people do use these methods depending on the complexity of a particular situation. Now, this is while he is alive, and let's say he has made a will and he has given the property through will to one son and he has kept the others out. Well, that will can be challenged. Let it be known that if a property has not gone to one of the legal heirs, who were the natural legal heirs or the class 1 legal heirs, and he has chosen to give it to one or two and leave out the rest, or leave out one person, as he may deem fit, he can very well do so through will, which is exercised after his death, executed after his death. And the only thing is that that will can be challenged by the other legal heirs who are not the beneficiaries of that will, and that can become a subject matter of the courts, and litigation can take place. And then whether that will is genuine, whether that will is right, depends on the validity of the will, the genuinity of the will. It is all a subject matter of the court's decision. And once the court adjudicates on it, gives an order, then the court order prevails, whether they uphold the will or they set aside the will. And on that note, let me also tell you that under the Indian law, will is not the primary document of succession. In India, there is a definite and a clear preference to natural law of succession, and natural law of succession in India is all the class 1 legal heirs. That is, when a man is deceased, it is his wife and children, all of them co-inherit the property in equal shares. And when a woman dies, if it is a self-acquired, then it is husband and children, and if it is ancestral, then it is only the children. So this is how the natural succession progresses in India, and there is a lot of preference over the will. However, a man can choose to bequeath his property to anyone that he desires. And then there is another question which is completely aligned with this, is that how can a property be transferred after the death of a husband? Exactly what I have just told you. Transfer of property after the death of the husband can be through two ways. If he has left a will, then it can be transferred on the basis of the will. And if there is no will, that is, a man dies intestate, then the transfer is done to all the class 1 legal heirs. So in a case of a husband, then the lady must know that the property will devolve on her as well as all her children, living children from the wedlock. So all of them will co-inherit the properties. I would also like to tell you that if a husband has had another wife and children through that wife, then they stand legal heirs as well. Any living legal children and wife co-inherit the property, and the transfer can be through will or through natural succession, and that kind of covers both these questions. One more query that has come is that what are the property rights of a wife after the husband's death? Let this be very clear that when a man dies, according to the succession laws in India, it is not only the wife who inherits, it is the wife and all the living legal children, all the biological legal children of the man. And if in any circumstances the man predeceases the mother, then even the mother gets a share. So right of a wife is absolute, there is no doubt about it, but she is not the only inheritor or the only person who gets the entire property in her name. She has to co-share it with, if there is a mother alive, then with the mother, if all the children, with all the children in equal shares in equal proportion. And the way, if the husband after his death, there is a will which is only in the name of the wife, then succession can be given to the wife alone. But however, the will has to be executed, it has to be proven, and also no objections on the will has to be sought by the other legal heirs to give the wife the absolute right. So will and also natural succession, which I have just elaborated upon, are all parts of the succession laws in India.